There is no nation under the sun that are better lovers of justice than the Irish, nor who will rest better satisfied with the execution thereof, even though it be against themselves, so that they too may have the benefit and the protection of the law when upon just cause they do desire it. That statement was made by Sir John Davies, who represented the British Crown in Ireland as the Attorney General of Ireland. He is not a man who was in favor of the Brehon Law. In fact, he was a man who was instrumental in the final abolishment of the Brehon Law. That's what makes this statement all the more poignant. This is not a friend of the Irish or of the Irish customs and way of life. Yet he said, there is no nation of people under the sun who are better lovers of justice than the Irish. That makes that statement all the more impactful. And it gives us a true insight into the relationship that the early Irish, our Irish ancestors, had with their system of law, with their system of justice. I'm going to share a few more quotes with you in this short kind of impromptu video. So John Davies speaking on tanistry, and if you want to know more about tanistry, check out my video on that. To give you an indicator of what he actually thought of the Brehon Law, he said that tanistry is the cause of such desolation and barbarism in the land as the like was never seen in any country that professed the name of Christ. He was not a friend of the Brehon Law, yet he said there is no nation of people who loves justice more than the Irish themselves. Lawrence Ginnell, writing in the Brehon Law's A Legal Handbook, which you can get on the Brehon Academy Library, said, "A nation's law is an irrebuttable witness to its character, a mirror that cannot be disclaimed. We should in justice remember that it is in general an unfavorable witness, an unflattering mirror." What he's saying here is the codes of conduct which a people of a land subscribe to give a very clear indicator of the character and nature of that people. It tells us about their standards, their moral standards and social standards. It tells us about their aspirations. It gives us an insight into who they desire to be. But it also shows us the flaws. It also shows us the common mistakes and breaches of justice, the grievances that were common to arise among those people. And this is why he says it can be an unflattering mirror. In the case of the Brehon Law, however, I think we have much to admire in that reflection. I think it's a beautiful reflection. One of the clear distinctions between the Brehon Law and the English common law, which was one of the reasons why these English writers, British writers, looked at the Brehon Law with such repugnance, was, for example, that we didn't kill people in our law. Very, very rarely. There was some very rare circumstances. But as a general rule, there was no death penalty. There were no prisons. There wasn't even a body of enforcers like the police who made the law work, who forced people to comply with the dictates of the judge. In this sense, it was a law that was upheld and supported by the people themselves who loved justice. I can't emphasize this enough because I think it's a tragedy of Irish history that Irish people have forgotten that their character, a thing that made the Irish characteristically Irish, was their love of justice and their native Brehon code. Ireland was colonized, brutally so, for several hundreds of years. These laws were not given up voluntarily. Our language was not given up voluntarily. Our way of life was not given up voluntarily. Our language was ripped from our tongues. Our laws were snatched from our hearts. And in the course of time, sadly, our traditional customs and way of life was forgotten. If you think about Irish culture today, and if you ask an Irish person about it, they might talk about the language and the remnants of it and how it's still spoken in the west of Ireland, and isn't that a great thing? If you ask most Irish people, can they speak Irish? They might say, ah, cúpla focal, a couple of words. I find that as well, that Irish people often, if they can't speak Irish, get kind of defensive about it. They say maybe something like, sure, why would I want to speak Irish? It's a useless language. And I think that really stems from deep down a hurt. We don't like to be confronted with the fact that we no longer, for the most part, most of us cannot speak the language of our ancestors. But more than that, people might talk about the Gaelic Athletics Association and how we have our ancient sports, our Gaelic football, our hurling, our camogie, and how that these sports go back thousands of years. In fact, we don't even know when they begin. We might talk about our Irish music, which is still flourishing. We might talk about how Irish culture has been commodified and commercialized and reduced to green plastic keychains of leprechauns or St. Patrick's Day and green Guinnesses. But for me, and part of the mission that I have with this Brehon Academy is to remind Irish people of this aspect of the Irish character that was undivorceable from the Irish psyche and the Irish people in earlier times. There was no nation of people under the sun that loved justice better than the Irish. I'm going to read a little bit from an article called The Bentham Bar in Ireland by a barrister called R.W. Bentham. And he was writing in 1958, was when this was published. To give a little bit of the background of this law. In Ireland, the tradition of profession of legal experts is older than Christianity. Of the Druids of Ireland who composed this profession, we know little, since almost all of the records of ancient times were destroyed during the English campaigns, ranging from the 14th century to the 18th century. Now, I would say, add to that, that the campaigns actually lasted a lot longer than that, but for the most part, in the beginning, they were confined to certain parts of the country, and the rest of the country just continued pretty much as normal. But from such records as have survived, some picture has been left of the customary law, which, in the main, regulated the human relationships of Gaelic Ireland from pre-Christian times until the 17th century. The administration of justice by the Druids, whose lawyers, when Christianized, were to be called Brehons, was sacramental, as in other early societies. I'm going to add here that I'm not sure to what extent it was because they were Christianized that they became Brehons, but in earlier times, the office of Druid, Fili, or poet, judge, Brehon, and Shanachie, storyteller, were all composed in the one office of one man or woman, who we called a Druid or Druidess. But as time went on and these fields of learning became more advanced and built out, people professionalized and specialized in certain aspects of these roles to give us eventually the class of individuals who we call the Brehons. He continues, the Druidical class, composed of learned men, priests, philosophers, and judges, was dedicated to the suppression of violence and the maintenance of the rule of law between individuals, chiefs, and kings, their ideal and attractive one in an age of extreme violence. It was a rule of law based on morality, revealed through thought and ritual by the will of an unseen power. Such men, for the most part, became ideal subjects for the so-called conversion to Christianity, effected by Patrick in the 5th century. The notion of one God and the apparent magic of the sacraments being most attractive to them. Patrick was too wise to attempt, or probably even to desire, a complete departure from the prior established order of things. As a result, in his time, the existing law was revised and in some degree, Christianized by a committee of 9 made up of 3 kings, the King of Ireland, Munster, and Ulster, 3 bishops, of whom Patrick himself was one, and 3 lawyers. I would say 3 learned men. The commission eliminated, we are told, much of the pagan ritual from the proceedings of the courts and evolved what we now call the Great Code, the Seanchas Mór of Brehon law, that was to rule the greater part of Ireland until the 17th century. I would add that apart from the 3 bishops, I think only one of these kings and one of these learned men are what you could call a nominal Christian, that they had converted. But the rest of those involved in this codification of the Brehon law still clung to their traditional Gaelic beliefs, spiritual beliefs, which we call pagan. I'm not sure how useful it is to say that, but to use the word pagan, but the Gaelic traditional spiritual beliefs. Bentham continues, it is to the Great Code, as it worked and was amended as the years passed, that is owed such knowledge of Brehon law as now exists. But Patrick's Code did not banish magic from the law or from Irish life. For instance, there is told the story of a great Brehon whose judgments were always infallible. But it was not until his death that his secret was discovered. He had a magic collar which choked off wrong judgments, so that only truth could come from his mouth. Had such haberdashery survived, the rate of insurance on the lives of modern judges would be prohibitive. This is a very, very brief glimpse into that mirror of early Irish law and the society of the time. It was a land possessed of this ancient legal tradition, with law administered by laymen and based on custom and ritual, presupposing continual tribal conflicts, yet providing the legal machinery to end them, that the Norman Welsh invader came in the 12th century. Even in the midst of the fighting, intrigue, and confusion which led to the request for help sent by MacMurrough, King of Leinster, to the Norman Richard Fitzgilbert, the parties to the dispute, MacMurrough, King of Leinster, and O'Rourke, seem to have gone to court, where the matter was concluded in O'Rourke's favour with an award of 100 ounces of gold as damages. So even in such a time as we find ourselves in the 1100s in Ireland, even when there was conflict and intrigue, and that story of MacMurrough and O'Rourke is an interesting one. There was wives being kidnapped and everything. Even in circumstances such as this, the laws were there to help people to find peace within the society. Jumping back to Lawrence Ginnell in the Brehon Laws, a legal handbook, he wants to point out that the Irish law is characteristically Irish. It's not Roman. It's not Hindu, even though there might be some similarities. It's characteristically Irish. In the same way that the English common law is characteristically English. He says, there are no 2 systems of law of which I have any knowledge which do not contain some points in common. But the fact is that in the Brehon laws, such coincidences with Roman law are really fewer than might be expected without deviation at all. The coincidences with Hindu law are actually more numerous, yet no one would suggest that the Brehon laws are derived from the Hindu laws. Many of the Irish laws are as old as the Roman law itself. Whether they are good or bad, creditable or otherwise to our race, they are essentially, substantially, and characteristically Irish. And he adds, the Irish laws were in several respects more humane than the Roman. Then with regard to the treatment of strangers, to give an example, at Rome for a long time, an alien or foreigner was an enemy who might be ill-used whose property was res nullius, which any Roman might seize, and who had no locus standi, it's like standing in court, whatever, before a legal tribunal. But in Ireland, a stranger was a person entitled to sympathy. His property could not be taken from him. And not alone was he heard in a court of law, but he was allowed to choose his own judge in that court of law. He goes on to say that all British laws were modified under Roman sway, which Ireland escaped. Of course, the laws of the Gaels of Scotland were originally our laws transferred to Scotland. They, however, underwent considerable change, for feudalism was vigorously forced upon Scotland in the Middle Ages. There's a really crucial point here that makes the Irish law, not just the Irish law, but the study of Ireland, very unique in the European context, and that's Rome. Ireland was one of the few countries which the Roman Empire did not reach. There's many reasons people have for that, and we don't really know the true answer as to why. Some people would like to say that the Romans were afraid to come to Ireland because of the legends of their great warriors. But in any case, they didn't get to Ireland. And so the order of the society, the laws in use, and so on, remained characteristically Irish without this interference of a foreign power of Rome. The same cannot be said of any other European country. So when we're looking at Ireland and Irish law in this context, we see an unbroken chain of tradition that goes back into very ancient times. There's a great book on this topic called How the Irish Saved Civilization, which talks about the state of Europe after the fall of the Roman Empire and how it was Irish missionaries and monks, educated men, who went on missions to Europe to found monasteries, centers of learning, to bring back knowledge, wisdom. It was said in those times that if you could speak Greek in Western Europe, you were presumed to be from Ireland, because Ireland was the only place at the time that had schools that were still teaching the classics, that were still teaching Latin and Greek philology. This was where we get the idea of insular sanctorum et doctorum, the island of the saints and the scholars. It's important to point out that the Irish did not give up this code and way of life willingly. It did not fade away because it was supplanted by a better system. It was brutally snatched from their hearts. I was asked this question in a recent talk that I gave, like, was there a statute or something that replaced the Brehon law? And it's hard to put your finger on one particular piece of law or circumstance. You really have to take a wider view of Irish history and the Anglo-Norman invasions up until 1600s, when you had the Battle of Kinsale, which led to the flight of the Earls, which was when the last great chieftains, the leaders of the great families, fled the country. They went to Europe to try and get help from their Catholic friends, which never came. And after they left, because the order was kind of supported by the nobility, and they had, protected the Brehons and I guess kind of protected the way of life and culture, that after this it provided the opportunity that the English invaders had been looking for hundreds of years to finally eradicate and stamp out the Brehon laws of Ireland. This brings us into the period shortly thereafter of the penal laws, which is a brutal period of Irish history, which I won't go into too much detail now. But to return back to Lawrence Ginnell, he's talking about a so-called parliament consisting mainly of self-elected English officials that was held in Kilkenny in 1367, and an act was passed. This was the Statutes of Kilkenny, written not in Irish, nor even in English, but in Norman French, branding the Irish as enemies and penalizing the adoption of their dress, manners, language, and laws. All over the country, except the Pale, the Brehon laws, like sun through a storm, prevailed in some way. For other law, there was none. On the topic of the Statutes of Kilkenny, it must be borne in mind that the reason that these statutes were created was not directed at the Irish natives themselves, but it was more so directed at the earlier Anglo-Norman settlers who had moved to Ireland during the first wave of invasions, I guess, and had settled in certain parts of the country, notably the Pale, areas around Dublin and Leinster, so on. And it was only in these places that the English law was actually being used. However, over the course of time, these settlers, these Norman settlers, began to adopt Irish ways. They began to speak the Irish tongue. They began to wear Irish clothes. They began to let their hair grow long and wild as the Irish did. They didn't ride their horses with saddles in the manner that the Irish did. And most importantly, but also the biggest threat to the crown, was that they stopped going to the British Crown courts for justice in favor of who? Our Brehons. And history doesn't clearly answer that question as to why, but I'm sure you can feel in your heart why. I'm sure your imagination can lead you to some fairly accurate conclusions as to why these settlers abandoned this English law, Anglo-Norman English law, in favor of the Brehon laws. During Elizabeth's bloody reign, to return back to Lawrence Ginnell here, such old Brehons and Ullavs as may have been then living sank into obscurity and into the grave without successors. And Ullav was a professor, it's like the highest grade of learned man. And it wasn't until the reign of Elizabeth that they really began, as to use Ginnell's poetic words, to sink into obscurity and into the grave without successors. Night had fallen on the Gael, and justice, as a living presence, had been banished from among them. Justice, as a living presence, had been banished from among these people who love justice more than any other nation under the sun. If they suited ancient conceptions, they fulfilled the object of their institution. That they did this to a large an extent as any other laws, past or present, is sufficiently established by the enormous length of time during which they continued in force. And in force, remember, by the will of the people. They sustained by the will of the people. Our ancestors, like ourselves, had faith in reason and good example, not in the thumbscrew. Now, with more direct regard to the Brehons and Ullavs, any modern reader will be at once struck with the want of scientific arrangement in their work, and with the manner in which they open a new subject, in the middle, so to speak, instead of at the beginning as we should desire. I think that merits a little bit of elucidation. When you read the Brehon laws, and if you can see this in my course, in the section on manuscripts, they didn't start at the first line and write downwards. There would be a big line of text sort of in the center of the paragraph. And how you read it was you read the big line of text, then you read the smaller line of text directly above it, and then the line below that. and then the line above that, and down, and this, and down, up and down. So as you started with the core principle, you expanded out in both directions, both up and down, each sentence adding context, adding meaning and depth to the core principle that was written in the bigger text. So this is what Ginnell is talking about here, that when they open a new subject, they start in the middle, so to speak, instead of at the beginning, as we should desire. He also talks a little bit about the difficulties with translations, and this is something that I lament personally as well. I am treating the materials that I have access to through English. I'm not fluent in Irish for reasons, as I've mentioned in this video. And the Old Irish is very hard to approach. You need like a scholarly understanding of Gaelic. And sadly, the number of people who have that scholarly understanding is diminishing year on year. There are many manuscripts in the libraries of Trinity College which remain untranslated. We don't even know what's in them. What gems are waiting to be discovered in these manuscripts? Not to mention the libraries of the private households, private libraries of so-called noble families of England who exported our manuscripts. There's many of our manuscripts in libraries in England, like Oxford Library and so on. I would love to see a campaign to return those manuscripts to their rightful place. So Ginnell says that law, at best, is not the most fascinating of subjects. I disagree with that, but that's what most people think. Very handsome things have been said of it, and justly, but they have been said mostly by lawyers. It is, among other things, the bulwark of the righteous, the shield of the weak, the noble science of discovering in circumstances of great complexity what is just, and making the balance play on its pivot with strict impartiality. A nation's law is an irrebuttable witness to its character, a mirror that cannot be disclaimed. We should in justice remember that it is in general an unfavorable witness, an unflattering mirror. It reflects cases, disputes, quarrels, and lends undue importance to the comparatively few members of the population who figure in them, while almost wholly ignoring all the sweetness and goodness of human life and the vast numbers who pass through life without a legal dispute at all. I want to come back to now R.W. Bentham, the bench and bar in Ireland. Before I do, I'll repeat that quote again from the beginning. There is no nation of people under the sun who are better lovers of justice than the Irish, nor who will rest better satisfied with the execution thereof, even if it be against themselves, so that they too can have the benefit and the protection of the law when upon just cause they do desire it. Keep that in mind. Bentham says, writing in 1950s, Irish irreverence for law does not stem from sympathy with crime or wrongdoing in general, but rather from the fact that the Irish, who have a longish memory, are aware even now that the law in Ireland is not Irish law. However just it may be, and it was once most unjust, it does not command reverence as a native institution, but simply respect nowadays as an essential part of the machinery of government. Irish irreverence for law does not stem from sympathy with crime, but from the fact that they know in their hearts, deep down, that the law in Ireland today is not Irish law. And it might be just, but it doesn't command reverence, respect, even a sacred nature, as a native institution of Irish justice. This is a tragedy of our history that has never been addressed, resolved. I can tell you that when, after the War of Independence and the Irish Free State was established, there were statesmen of the time who did discuss about potentially returning to the Brehon laws. But you have to factor in that since the 1600s, 17th century, up until the 1900s, the British establishment had firmly gotten hold of Ireland. And that's several centuries of people who have been doing things in the British way. The courts, even the perception of the legitimacy of the courts and the authority of the judge is something that is fundamentally psychological. And how can you replace that then willy-nilly with just what would have been to them some new system, some new way of doing law? This was a challenge that obviously they weren't able to adequately address. In fact, I was disappointed to learn that a lot of this conversation was centered around, well, what will we wear? The British judge has the black robe and the wig, and this, in a psychological sense, commands some sort of authority in the same way that the doctor wears the white coat. Okay, it's like begs the question: why should I do anything that this guy in a black dress says? But the whole court and ceremony of the practice of law creates a compulsion on the ordinary viewer, on the ordinary participant, the common man, where they feel that they must, or that they have to do what this man in a black dress says. And this was seen to be a potential barrier to reinstating the Brehon laws, because what are we going to wear that will be quintessentially Irish and characteristically Irish, but still command the respect and reverence, and not a room full of laughter if they walk in wearing some sort of like nature hippie robes, and I don't know, with a laurel of oak leaves in their hair. Who knows what could they have done? Because unfortunately, there's not much written about this in early Irish manuscripts, at least not what I have found. They would have dressed how other people dressed. Maybe they would have had more colors in their robes to signify their status, but more or less they would have dressed how other people have dressed. So there's something there for me. There's something there. A remedy is being begged for. At least an acknowledgement. Maybe that's enough, but it's a start. I often get asked the question as well, like, can you use Brehon law today in court, or are there any examples of this happening? And it's few and far between. And having studied law myself, I have a bachelor's degree in law, turned out to be quite good at it. I did very well in university, finished top of my class in my penultimate year. Also, I have a master's in politics, philosophy, and economics. So I give a lot of thought to these things from an academic point of view. I have the academic training to approach them from different angles, philosophically, in terms of politics, even economically, and of course, with legal thinking and jurisprudence. And while I would love if the courts in Ireland could just simply consider points of law from Brehon law, it would mean that they are acting outside of their actual capacity, because the fact is that this is British law. Yes, it's Irish common law. It's it branched off, and it has different, there's slight differences in how cases are determined based on the evolution of case law in Ireland versus England. That's a fact. But the very nature of the law, the adversarial system of it, the retributive aspect of it, the authority of the judge, the unapproachable nature of a judge, how his judgments are just like cast down from his bench without, like, you could say, cause for sympathy, without a desire to create peace and healing within the society. They're quintessentially British, and so are our Houses of Parliament. Bimacaurial system of the House of Commons and the House of Lords in Ireland takes the form of Dáil Éireann and Seanad Éireann. So all very quintessentially British in nature, although has evolved since the founding of the state back in the early 1900s. But there is one example that I have found. I think there might be two examples, but I can't recall what the second one was. But one example is what's called the Moy Fisheries case. And what I'm going to read now is from an article in the Irish Times that was published on 19th of March, 1936, where Mr. Justice Johnston was hearing a case from Miss M. Little and others who were seeking a declaration that they are the owners of several fisheries in the River Moy in the counties of Mayo and Sligo. And they were seeking an injunction restraining George Cooper and other persons residing in the Ballina district from trespassing on the fishery. The defendants, along with the Attorney General, argue there is a public right of fishing in the waters. Let me just clarify this. The plaintiff, Miss M. Little and others, they are claiming that they have some ancient rights to certain areas of waters on the River Moy in Mayo and Sligo, which come from the Brehon laws. These were ancestral rights, whereas George Cooper and others who were then kind of, I guess, encroaching on these rights claimed that there was a public right to fish here and that they weren't trespassing. Justice Kelly of King's Counsel, E.J. Kelly, King's Counsel, submitted that the Brehon law could not be regarded as foreign law. So the defendants were saying, excuse me, the defendants were saying that you couldn't use Brehon law in an Irish court because it was essentially foreign law. And this speaks to what I was saying a moment ago, that the judges in Ireland today are precluded from considering the Brehon law because it is a form of foreign law in the context of English courts. Judges are constrained by what they can, what materials they can use to determine the outcome of a case based on the parameters of the common law. Only cases that have been come before the court in the past have been decided upon. That's case law, and the legislation is set out by the Parliament. They cannot import novel pieces of law just because they want to, and that's arguably a good thing because we don't want judges kind of ruling, making law from the bench. They're constrained and confined by the existing laws set out by past judgments and legislation. Excuse me. So Kelly for the King's Counsel said that, well, Brehon law could not be regarded as foreign law, and that in no circumstances could evidence of Brehon law be excluded. Taking all law as based on territoriality, they in those courts were really the heirs of the places where Brehon law was once administered. Brehon law, which at one time applied all over the country, was gradually displaced and apparently last survived in County Donegal. If it became their duty to do so, they must ascertain what the law of this country was at a given period. Justice Johnston agreed to this, stating that he would have great difficulty in coming to the conclusion that Brehon law was foreign law in the sense in which a French rule of law would be regarded as a foreign law. I wanted to share this case with you, and I would recommend like going and doing a bit of extra research on this yourself. The Moy Fisheries case, it was called, because it highlights the kind of conflict and difficulty that the Irish had, even in the Irish judiciary, of grappling with this fact that the native law of Ireland is Brehon law, and it was never willingly or willfully given away. So to wrap up, there is no nation of people under the sun who are better lovers of justice than the Irish, nor who will rest better satisfied with the execution of that law, even if it's against themselves, so that they too can have the benefit and the protection of that law when upon just cause they do desire it. And Irish irreverence for law does not stem from sympathy with crime or wrongdoing in general, but rather from the fact that the law in Ireland is not Irish law. And I submit to you that Irish people know that deep down in their heart. I'm Kevin Flanagan from the Brehon Academy. Thank you for watching this video. If you have any questions, feel free to pop them in the comment box below. And until next time, slán go fóill.